abusia aha possible TV meji dis adom ne ahweye nti onyankopɔ adom yi na ye ho ye onim se possible TV de kan editi efa manyon nsem efa news no anase ne updates no possible TV heya na obenya no me no kase ye nya baako bi na onim se de no ye mo nwem ye nti nsema audio.
Still at the Supreme Court, now a few minutes later, and the apex court of the land, a ruling, Etuja said the application before them, the injunction application brought by 3 minority MPs, Haruna Drisu, Kujato Ablako, and Mama Yarigano, or ma dismissing. Now, sending CDMA a whole lot of reactions about Etuja. Yeti Haruna Drisu shamefully Jatum say they agree with the ruling and they will know what to do next and a whole lot of things. Yabremo how Edujitamaklu suffered much at the court trying to convince the 7-member panel chaired by Justice Nene Amegachi. CCA and Yebura Mu the registrar office na yezaka ruling no na official ruling na say Supreme Court at the 5 reasons why omo dismissing the injunction application about Betuja in their ruling and don't am person near T4 com na ye the Emrano SCA and the reason why a 7-member panel no and 7 judges no omu nyina call ajunkromo omu gitum say so omu grant injunction application na ebe haje no eno na person no mo che na yedi kan reasons ni bi a che omu dada enti ebe wo so na eduru there yen kan che omu na yakọ into details. First reason I did kind of more yes, Supreme Court no a make order say if they grant the E-Levy injunction any because first of all no Ghana Revenue Authority per the act establish a Ghana Revenue Authority no it stated clearly said the Ghana Revenue Authority should have an IT equipment which is very, very good in their offices that will enable them to perform their duties equitably and effectively. And the Supreme Court was of the view say because of the IT deployment of the Ghana Revenue Authority and then the law now a back woman they have that faith with them and listening to the argument of Godfrey Odamino, the Supreme Court says Odami argument state said the IT deployment system of the Ghana Revenue Authority is able to detect wrongful payment, overpayment, and non-payment of taxes. In the case of refund, the IT deployment can be used for refund. And the Supreme Court held say, based on that argument, they agree with the Attorney General, and so they are dismissing the injunction application. Second reasons are Supreme Court and the second reason, is familiar with the first reason. Second reason, say they don't want to grant the injunction and they wouldn't grant the injunction application because they can make orders for the Ghana Revenue Authority. And over Ghana Revenue Authority order Supreme Court we order the Ghana Revenue Authority to keep accurate records of the amount deducted so that at the end of the substantive matter nobody will be disadvantaged. And now all can say Supreme Court second reason say they can make orders to the Ghana Revenue Authority say they should keep proper records. Say in case say you this substantive matter that's a shift could the NDC MPs in inside now more near the Ghana Revenue Authority can go ahead and then refund everyone's money to the person, whether the person is a male or a female or whoever. Now there will not be some form of disadvantage. That was the second reason. But the money a copy or court no the third reason was that Supreme Court no section 37 of the Evidence Act. On the ruling now, and the third reason we now some of the book on the ball injunction application it also. So section 37 of the Evidence Act now say naturally or say acts of parliament are presumed to have been regularly performed until determined otherwise by a court. So the Act 37 of the Evidence Act nature says parliament nebedane act of parliament or me pass a bill nebedane. It is presumed say the passage of that bill and that law no, was regularly performed. The passage was regularly performed until it is presumed or determined otherwise by a court. And so the Supreme Court will say is that based on the Section 37 of the Evidence Act, the passage of the E-Levy was presumably passed. It was passed. It has been presumed that it was passed and effectively and diligently unto say a certain court of competent jurisdiction ever turning over another ebe prove otherwise say the approval of that law was illegal the matter or the law still holds inti udeba E-Levy ma Section 37 of the Evidence Act protect Parliament about emrana or mayor in such a way that until the court to be determined say some E-Levy bill passing no court can rule on that and say it was illegal until say a certain court has declared into me so and granting the injunction application because for now court to be or grant to say the passage of the E-Levy was illegal. That was our third reason. Our fourth reason was that into Section 37 the panel ruling said we are therefore enjoined by the law pending the determination of the substantive matter presume the regularity of the act passed by the Parliament. And so really on the mind as to Section 37 of the Evidence Act. Fourth reason. Number fourth reason, nice to say, the question is the statement of case NDC MPs in the filing. They argue say irreparable damage will be caused to the public if the court reneges on granting the injunction. In the NDC MPs, and as a council, a legitimate argues say there will be damages to the public and the citizens of the country if the court does not grant the injunction. And on a court also disagree with the lawyer Dujitamakulu and NDC MPs, because and one reason is that allegations now Dujitamakulu say there will be irreparable damage to the public. It is based on conjecture, and Supreme Court was saying we don't go to court with conjectures. And so the applicant submit in paragraph 19 of their statement of case that irreparable damage will be done. It is not clear how they came to this conclusion and can only consider it was just a conjecture. The Supreme Court ruling nature say counsel for a NDC MPs on statement of case paragraph 19 actually said there will be irreparable damage to the public. And the Supreme Court say evidence actually said there will be damage to the public and say. So when say it is based on conjectures, it is based on imaginations. We don't come to court with also imagination, we come to court with evidences. And so when you imagine a court on Gaza, there will be irreparable damages to the public without evidence. Therefore, Oman dismisses paragraph 19, and dismissing paragraph 19 shows that they cannot grant the injunction application. Last reason dismiss the E-Levy application was that in the application, filing, the implantation of the E-Levy will cause hardship to the users of electronic payment and mobile money transfer platforms. And the application say pass E-Levy now, it will cause hardship to people who uses mobile money and the other thing. And on a court, they disagree with that statement. And one reason say it is rather the state that stands a greater risk of hardship if it goes ahead to grant the injunction. So the Supreme Court was saying that between the government and the citizens, the one who will suffer great risks and the one who will suffer very, very much hardship, is not the citizen, it's rather the government, because the government will not be able to cover all the expenses that will be losing. And if they grant the injunction, they will be suffer the damage, they will suffer the hardship, is that of the government, but it's not that of the citizen. And based on these 5 reasons, they cannot grant the injunction application and more dismiss it. The 5 reasons are Supreme Court they are per the registrar ruling now releasing my SMP these are the 5 main reasons why court or dismiss the E-Levy application, reactions about Okujetu Blakwa, and so the reaction about Betuja and a whole lot of things. They remain resolute despite the dismissal of the E-Levy, injunction. They will still focus on and wait for the substantive matter to be determined. This shows clearly there will not be a review application. But deep down, these are the 5 reasons why the Supreme Court 7-member panel led by Justice Nene Amegachino or dismiss the injunction application. You can't determine say in same people Supreme Court you say this time round any Justice Dondochi nebe preside likely say Justice Nene Amegachi. Yeah, the judges kakrebi din to just say likely say Justice Unicolin the Sobetene General. Now say this show say same P sebi yakasa credible kakra. We don't want to bring false news to our dear subscribers. This is coming from the registrar's office about 5 reasons why this 7-member panel dismissed the E-Levy application.